In the long-awaited Karen Reed retrial, it appears the jury has pretty much shaped up. There is a pending motion by Aiden Kearney to keep him from being thrown out of the hearing. And you know what? For those of you who keep saying Massachusetts is very corrupt, we have a couple of little items for you at the end of this episode.
Andrew always tells us not to paint the Massachusetts police with a broad brush, but is there actually some corruption going on?
No, never. Never, not in Massachusetts. But before we get to that, and we will get to that, in the Karen Reed case, it does appear that the jury's pretty much selected. But you know what? Mr. Kearney, also known as Turtleboy, has been put on the witness list, and that keeps him out of the courtroom. So there is a motion pending to allow him back in. Here it is. It's called Intervenor Alleged Witness Aiden Kearney's motion to be exempted from sequestration order. Now comes Mr. Kearney, by and through his attorneys, and respectfully request that this court exempt him from the court's sequestration of witness order. In support of his motion, and we're going to skip the background because we think our viewers know it all.
Hopefully.
So we're going to start with what's really relevant here. Paragraph 4 says, in what appears to be the latest move as part of their ongoing plan to silence Mr. Kearney by suppressing his critical coverage of this case, the Commonwealth seeks to exploit the sequestration order by naming him as a potential prosecution witness, which would subject Mr. Kearney to the routine general sequestration order entered in the case, lead to his exclusion from the courtroom, and prevent him from reporting on the case. In essence, they're trying to keep Turtleboy, Aiden Kearney, out of the hearings and out of earning a living. In essence, the mere act of naming Mr. Kearney as a potential prosecution witness would enable the Commonwealth to silence a journalist who is an influential supporter of Karen Reed and a leading critic and foe of the prosecution. The Commonwealth's desire to entirely gag and sequester Mr. Kearney such that he could not even observe the proceedings or discuss them in any manner will harm the public's right to information on an important matter of public concern, since many people rely on his reporting for updates in the case.
In considering the Commonwealth's motive for placing Mr. Kearney on their witness list, thereby subjecting him to the sequestration order, the court should take note that this is not the first time the Commonwealth lead counsel Brennan appears to have exploited a witness list by including journalists critical to his position on it for the purpose of suppressing their ability to report on the case, rather than for good faith reason to examine the journalist/purported witness. In U.S. v. James Bulger, the defense team, which included Mr. Brennan, sought to exclude 3 journalists whose reporting was understandably critical of Whitey Bulger, a notorious and treacherous gangster and murderer, by naming them as a potential witness against Bulger. The court denied the defense's effort to exclude the reporters from the trial, finding little danger of fabrication, inaccuracy, or collusion. The court noted that the First Amendment interest of the journalists to report on a high-profile matter of great public concern outweighed the minuscule risk that if called as impeachment witnesses, their presence covering the case as journalists could shade their testimony. The court also questions the defense's claim that testimony from any of the journalists would be admissible or necessary.
Here, in this case, the ostensible purpose for the Commonwealth's inclusion of Mr. Kearney on their witness list is to keep him on ice. I love the way this is written. To keep him on ice as a potential rebuttal witness regarding Ms. Reed's purported consciousness of guilt based upon her alleged communications with Mr. Kearney. Notably, the Commonwealth already has represented to the court that they do not intend to introduce any such evidence in their case in chief, and that they only intend to do so on their rebuttal case if the defense, quote unquote, opens the door during cross-examination of witnesses the Commonwealth alleges were intimidated by Mr. Kearney and Ms. Reed. At best, the purported evidence of Ms. Reed's consciousness of guilt And Mr. Kearney's testimony in support of such a claim is weak, speculative, and to the extent that it is even remotely admissible, its probative value almost certainly will be outweighed by its prejudicial impact. Thus, without regard to the merits of the Commonwealth's speculation about Mr. Kearney's knowledge or ability to provide relevant evidence of Ms. Reed's purported consciousness of guilt, the likelihood of the admissibility of the evidence and or the Commonwealth's need for Mr. Kearney's testimony at trial is virtually non-existent and is substantially outweighed by Mr. Kearney's First Amendment right to report on the case and his right to earn a living.
Assuming arguendo that evidence of Mrs. Reed's conscience of guilt based upon her interactions with Mr. Kearney is admissible, it is hard to fathom why the Commonwealth would deliberately draw attention to Mr. Kearney's actions and his motivation for them by calling him as a witness without having any opportunity to speak to him in advance of his testimony. It strains credulity that experienced prosecutors would willingly afford Mr. Kearney the opportunity, on direct examination no less, to explain and then place in context the substance of his purported communications with Miss Reed, where such evidence clearly would be harmful to the Commonwealth's case and almost certainly support the defense's position. Simply put, the likelihood that the Commonwealth will actually call Mr. Kearney as a witness appears virtually non-existent.
So that's the meat of this motion, to get Mr. Kearney into the trial so we can watch it and report on it. I mean, it's very clear that Mr. Kearney's First Amendment rights as a journalist to continue his reporting on a matter of great public concern and his right to earn a living substantially outweigh the Commonwealth's dubious and transparent speculative assertion that he may be needed as a rebuttal witness. It's a very well-written motion. I love the way they write the Commonwealth's dubious and transparent speculative assertion. So, I mean, I have been told we don't have a hearing date as you and I sit here now, but I have been told that we will hear it pretty soon. The other thing that's happened since our last episode, the United States Supreme Court has said, no, we're not going to stop the trial and we will not issue a stay. Here's a newspaper article that appeared. So the United States Supreme Court has denied a request by Karen Reed's appellate attorneys to halt the upcoming retrial through a legal stay. That's what it's called when the court says, no, we're not going to stop the trial. Back on April 1st, the same day that jury selection began, appellate defense attorney Martin Weinberg filed a petition to the U.S. Supreme Court to consider Reed's case. He had also asked for the Supreme Court to issue a stay to the state courts until it has decided whether it will take up Reed's case. So on Wednesday, April 9th, with the jury being selected in Dedham, Associate Supreme Court Justice Ketanji Brown Jackson denied the request to stay the proceedings. Also on Wednesday, however, Reed's Supreme Court docket reported that her request for their review of her double jeopardy claims was distributed for conference with a consideration date of April 25th, during which the court will decide whether it will take up the case. So what all of that means is that the Supreme Court is not going to issue a stay. They won't stop the trial, but it's still on their consideration list. And later on in a few weeks, they will consider whether they consider it. And that's all they do. The Supreme Court doesn't have to take up any case they don't feel is of significant public importance. So they'll decide, and we'll know later in the month. And a lot of people have speculated that they probably will not take it up. So
it's like not of public importance. Meanwhile, it's one of the biggest global cases.
I mean, double jeopardy is a very important issue. There's no question about that. But the thing about that is that, it was jurors A, B, C, D, and E, and Ronnie who said that, the jurors did come to a not guilty on counts 1 and 3. But, it's a matter of form over substance or substance over form as to whether or not it was a actual verdict. And that was a real sticking point. Vanity Fair is at it again, and there is a new article that came out while the jury was being selected. This article came out on April 10th. Karen Reed's second murder trial is already a spectacle. Karen Reed on her second trial, the firing of Michael Proctor, and a facing off against Whitey Bulger's defense lawyer in court. And I guess those are we're so deep into this. We've been following all the hearings and all the motions and all the paperwork. But I guess, if you're, looking at it from a 30,000-foot view, those are the things that other people are looking at in this case. Last week, Karen Reed returned to a wood-paneled courtroom about 25 minutes southwest of Boston for her second murder trial. 12 jurors had already determined that there was not enough evidence from Norfolk County District Attorney Michael Morrissey to convict Reed of second-degree murder and a lesser charge of leaving the scene of a deadly accident, according to 2 jurors who spoke to Vanity Fair. After a mistrial was declared, 5 jurors came forward to say that the voting body had only been split on the manslaughter charge, but had not understood that coming to a partial verdict was an option, according to Reed's lawyers. And now, against a backdrop of escalating appeals, arguing that second murder trial would violate Reed's double jeopardy rights, the former equity analyst, that's Karen, was back in the defendant's seat, or will be.
The initial trial had riveted Massachusetts. Reed was accused of drunkenly killing her police officer boyfriend, John O'Keefe, by hitting him with her car and leaving him to die on the lawn of a home belonging to another Boston cop, Brian Albert. As Reed previously told Vanity Fair, she believes that she is being framed in a corrupt saga involving 4 law enforcement agencies, including the Massachusetts State Police, whose troopers work out of Morrissey's office and investigated O'Keefe's death. In Massachusetts, homicides outside of Boston and a few other cities are investigated by state troopers. Morrissey's office declined to comment. That trial ended with a hung jury and a worldwide attention. In her second trial on the same charges, Reed again faces life in prison if convicted of murder.
Oh, so Mr. Morrissey's office declined to comment to Vanity Fair, too. So I don't feel so bad that, they ignored my correspondence that I sent them way back in October, a half a year ago. So Reed has now expanded her legal team of David Yannetti, Alan Jackson, and Elizabeth Little, adding Robert Alessi of New York and Victoria George of Massachusetts, a juror from the first trial. And I like this, 9 law students who will act as clerks, including Sophia Hunt, who recently served as Harvard Law Review president, and Abigail Rosofsky, a former Fulbright scholar. Reed has already sunk 7 figures into her defense, liquidating her retirement funds, selling her house, and relying on donation. All 11 of her additions are working pro bono. Morrissey, meanwhile, has enlisted Hank Brennan, one of Whitey Bulger's defense attorneys, to act as a special prosecutor for the government.
Brennan has taken a more proactive approach than his predecessor in the first trial, Norfolk ADA Adam Lally. Last month, Brennan tried to obtain text messages between Reed and Yannetti, arguing that Reed had sacrificed the right to attorney-client privilege by discussing her conversations with the lawyer in interviews, which, this is my own interjection, is absolutely insane. Judge Beverly Cannoni denied the motion. Shout out, kind of. He also sought private conversations between Reed and Aiden Kearney, the blogger known as Turtleboy, contending that they would prove consciousness of guilt. Brennan argued that the motion before a different judge. After Reed and her numerous lawyers single-filed in during that proceeding, an entrance so dramatic it made local news, Brennan told the judge, "I'm not sure why we're being joined by Mrs. Reed's team unless they have a standing in this." Reed squinted at Brennan in disgust. He was later granted access to the messages.
Brennan found himself on the defense, too. In the last 6 months, Reed's team received 2 new batches of security footage from the Canton Police Department, where she claims law enforcement tampered with her car, the alleged murder weapon, and began to frame her. Reed alleges that her taillight was broken at Canton Police Department, with fragments later planted at the crime scene. Canton PD did not respond to, there they go again, not saying anything. Canton PD did not respond to Vanity Fair's request for comment. A recent police audit outlined mistakes made at the O'Keefe scene, but found no evidence of tampering, corruption, or conspiracy based on the new materials the hired intelligence company reviewed.
The new videos were turned over in October 2024 and January 2025, more than 2.5 years after they'd been recorded and months after Reed's first murder trial had ended. Some video obtained by Reed's team in October were clarified versions of what had been provided to the defense in April, as the original videos were extremely dark. There was no apparent chain of custody for the new videos provided in October, but there was a note from the Canton PD chief, Helena Rafferty, that read, "That's how it records. LOL. No tampering. Rafferty is on the witness list for the second trial."
Aren't we always told that we have to be serious and not joke around? And so there she is saying LOL in an official capacity about a really serious issue. The fact that the video of the car that the Lexus that Karen Reed owned was backwards, inverted, whatever you want to say. And it was, people were on the stand for a day and a half before they acknowledged, it was backwards. So while Brennan conceded that the video situation should have been managed better, he said the defense had not specifically requested this footage. It is the murder weapon. Hank, get a grip. Come down to reality. I mean, anyone would know that if the Commonwealth's theory is that Karen Reed backed into John O'Keefe and caused his death with her car, that's like a gun in a gunshot case, or the knife in the Kohberger case. I mean, the knife sheath, I should say, in the Kohberger case. I mean, wouldn't a kid who has watched one episode of CSI have known that, that's kind of important? But I guess they're saying no. So that's the article. That's the article that was in Vanity Fair. They seem to really be on top of this more than a lot of the media in Boston. I mean, I love some of the people in the media in Boston. I really do, but they're given 90 seconds for a story. And, outside of, they have done some specials. They did the interview after the Super Bowl. Ted Daniel over on Boston 25 has done a lot of good coverage, but largely, they really have not done a whole lot on the case. And I mean, that which they have done has largely been extremely favorable to the
prosecution,
law enforcement. Yeah. So do you know how people are always saying, Massachusetts is corrupt? And how, we get those comments, in our comment section that say that, Massachusetts is just corrupt. And I defend Massachusetts because, I went to college in Boston. I went to law school in Boston. I lived in the Boston area for a very long time. And, it's a great state. I mean, if you go to Cape Cod or the islands, or I lived out in Western Mass for a short period of time, it's beautiful out there. So I don't let people get away with saying, painting with a broad brush that, Massachusetts is this corrupt place. Then I get up in the morning that we're recording this podcast. I get up, and when I turn on the radio, that's what I listen to. That's where I get a lot of my news. I know I'm old. I listen to the radio, and look what I see. Now, this was in the Cape Cod Times. Massachusetts state rep arrested on wire fraud. Massachusetts state rep Chris Flanagan has been arrested and indicted on 5 counts of wire fraud and 1 count of falsification of records, the U.S. Attorney's Office for the District of Massachusetts announced Friday. Flanagan, who is a representative for the 1st Barnstable District, allegedly defrauded a trade association of tens of thousands of dollars, the indictment said. He allegedly used the funds for mortgage and credit card payments, campaign funding, and personal expenses. His lawyer, Greg Henning, said he was still gathering information about the arrest. Okay.
I wish I had that audacity.
all of those statements are allegations. We now turn to Boston. Boston City Councilor pleads guilty to federal corruption charges, will resign. This is according to WBUR, the public radio station at Boston University. Boston City Councilor Tanya Fernandez Anderson has agreed to plead guilty to federal public corruption charges in connection with an alleged kickback scheme, according to documents filed Tuesday in Boston federal court. All of this is within a span of a couple of days. All of this is within a span of a few days. The councilor agreed to plead guilty to 1 count of wire fraud and 1 count of theft involving federal funds. Prosecutors are seeking a sentence of 1 year in prison with 3 years of supervised release and restitution of $13,000, according to the plea agreement. Again, those are allegations, although there is a plea agreement requiring that she plead guilty and step down from the venerable Boston City Council. But when I first started following stuff in Massachusetts, as you know, I'm not originally from there. I moved there, went to college there, ended up staying here in beautiful New England. When I first started following the news here, 2 Massachusetts state senators, DiCarlo and McKenzie, were doing jail time for taking kickbacks in the construction of the UMass campus in Southie. And a third state senator, Kelly, if I remember correctly, took a plea. I don't believe that he did any jail time. If anybody out there remembers that, because this kind of dates me that I remember all of that. But anyhow, I'll stand by my statement that Massachusetts is a beautiful state. You can go to Cape Ann, you can go to Cape Cod, you can go to the beach. It's got some beautiful beaches. It's got a lot of good stuff going for it. A student can't wish for anything more than Boston. I mean, there's a lot of great music, a lot of great shopping, a lot of great hangouts. And so, I stand by my statement that let's not paint with a broad brush calling the Commonwealth, corrupt. It's getting harder and harder to stand by that every day.
I mean, it doesn't look pretty, especially even just considering everything that's came to light because of the Karen Reed case, even just Proctor, not being a part of the force anymore. It's just a little disturbing that all this news is coming out, and here we are on the second retrial of Karen Reed when you have the juries complaining that no, they did find her not guilty of those counts. So it's a little disturbing to say the least.
Do we have any comments this week?
I pulled some viewer comments from our previous video. So for those of you who have been watching our channel for a while or, may have seen our past video, we actually had attorney Betterow on, and you guys had some wonderful insight on that. We have Sir Winston Squeakerson saying, I always loved having Betterow. I know many of us have asked him to make his own channel, but appearing on other shows keeps him completely out of the production time and admin work sync of these things. With how many channels we see him on and the depth he can speak on, I'd much rather have him appearing with other people. And I thought this was such a good comment, especially considering how often we talk about how much work actually goes into these podcasts. So I appreciate the attribution of that, knowing that we put in a lot of work and that it is very time consuming and that being a guest is almost more impactful, so you're not spending hours of technical difficulties.
Yeah, because there are so many people that have podcasts now, and many of them are doing the Karen Reed case, because it's just one of those cases. It's like a train wreck. You can't look away, and so he is good enough to give many different people his time. I saw one episode that he was on for 3 hours, the Young Jerks. He was on for 3 hours, but he was asked a lot of good questions by the viewers, and we should probably have people submit questions for him for the next time we hopefully have him on. My suggestion to Attorney Betterow would be, he's a busy attorney. He's a former prosecutor in Manhattan, and now he's a very busy defense attorney in Manhattan. So my advice to him is have somebody help you to do the backup. Daniel, Alexander, 7392. I could listen to Betterow all day long. Nobody says they could listen to me all day. It's all about him. It's all about Mark Betterow. What about me? I think it's relatively simple. Judge Bev is doing whatever she can to convict Karen Reed. The sole reason for her rulings. She wants Karen Reed convicted. It's really that simple.
These are our viewer comments, not our own words.
Right.
Again, we always have to say that, but this is just what people are out here saying.
Yeah.
Southern Mom. I've been an auditor for 25 years. I find it ridiculous and completely inappropriate that those auditors opined on whether or not there was a conspiracy. If they independently came to that conclusion, then their independent work should be obtained by the KR team and used during the trial to debunk her paid for opinion.
Well, yeah. But they did, let's not forget, they did have some pretty sharp words for the Canton police. One was that they should have separated the witnesses when they talk. I mean, that is crime scene 101. One of the other findings among many was that, that crime scene should have been preserved and protected at the moment that John O'Keefe was discovered there. The scene should have been protected, whether they put tape around it or otherwise protected it until the very end. They didn't do that. And they were very critical. So, you can't really fault them for that. Brooklyn Rules, 61-17. Love seeing you guys together. Mark is such a pro, and I like to watch him with other pro lawyers. I really wish he was up there on the dream team and can feel his disappointment all the way out here in Bay Ridge, Brooklyn.
Yeah, I mean, a lot of people, I think, felt similarly. We were, despite having him on the guest, we were also looking forward to seeing him on the case. So while we're grateful that he gets to keep coming on to the podcast, that is a little bit of a bummer.
Yeah, so he, as I had said before, he's made the rounds. He's talked to other people. So he makes a contribution. I mean, there's something to be said for an attorney who is articulate. A lot of attorneys are very bright, and that's fine, but a lot of them clam up and don't want to talk. I mean, back when I was a TV reporter, you'd cover a case, you have to sit in the courtroom, and then you'd chase the attorneys down with the camera, which is no easy trick because the camera, weighs something, and sometimes it's snowing or raining or muddy or whatever. And you would chase down these attorneys, and a lot of times they didn't want to talk to you, or if they did talk to you, they'd talk in circuitous language. A lot of times they'd use legalese, which none of us would but Betterow's not like that at all. He's very open. I mean, he's talked to a lot of different people. When he speaks, he looks directly at you. He has a really good point. He uses not that he's not an intellectual, and not that he couldn't use the legalese, but he says it in ways that all of us could understand, and I include that with me, because sometimes, you get mesmerized by just listening to the things that he says because he is so articulate. So,
yeah, even when we have him on sometime, like last time we had him on, you made a comment to me to ask him, like, oh my gosh, I have my own questions, but even just listening to you guys talk, especially from the legal perspective of it all, is just so immersive. I almost feel like I'm watching the podcast instead of participating in it, because you guys just make such wonderful points. All right, so WTD E9F. I'm wondering if that's supposed to almost be like a WTF. Always enjoy your show. Great guest. On another note, Attorney Myers, your Red Sox enthusiasm is very strong. I recently sold a puppy and the people named him Fenway. Just can't get away from you Red Sox fans.
Yeah, I don't think I mentioned it that the day we recorded that episode when I was wearing my Red Sox stuff, that was opening day at Fenway, and it was not a bad day actually in Boston. So I don't know. It'll probably be the last time I wear my Red Sox stuff, unless they make it to the World Series. But
unless a lot of people start commenting Sox emojis today.
Yeah, we got a lot of emojis. Are we at the emojis section of our program?
For real? Yeah. No, I will say, if you made it this far, be sure to comment your Sox emojis. But furthering on to other comments, we also have the comments on our commentary video of the Kohberger dollhouse or doghouse. So this one is very long, very
good. great.
thorough. Yeah.
We didn't ask for an essay.
I did. Well, I thought this was a very good essay. So, kind of to just summarize, Pequalsa is discussing how they used to do the 3D walkthrough photography in real estate, and they were doing it part time. And he makes a good point that you have your tripod, you make the 360 video, and you're able to, and they say on average every 6 feet. And this is a technology that those who are interested in technology have seen, where now we have 3D videos that you can even see on your phone by moving around. So this is a technology that's, according to them, been around for over a decade at this point. But they did a very thorough job just explaining the whole process, which we won't go through. But even saying walkthrough that took you through all the shots made it more like a slide video. It's just like almost like the dollhouse, where you can have the 3D model of each floor and you can turn and view the floor plan. And I'm sure at least somebody, I mean, these videos even exist on YouTube, I believe, where people can have the 3D cameras and you can take your phone and move around and stuff like that. So it makes a good point as to why are we making these replicas that are not of scale to these houses when the technology already exists, that they could have given them whatever program or software or video, or even if it's just like a display, or you put on. Other comments were talking about VR headsets and being able to look around. The technology exists, that we shouldn't have to make these little replica dollhouses, that we should have a relatively to scale 3D model of this house.
Yeah, this is a really good comment. And there were other commenters that said the same thing, that there is software out there that is readily available. I mean, hey, folks, we're not in 1925. We're in 2025, and you can do amazing things with a computer. Mm-hmm. Even I can do amazing things with a computer. I couldn't do this, but I mean, we had other commenters say the same thing, that there's software out there where you can build an exact replica. The technology is there, that with the radar and the LiDAR and the microwave and the hamburgers, whatever they did in that house, they could have built a scale accurate model. So what's the need to kind of mumble and jumble and say, well, it's not, Your Honor, it's just it's like a chalk. It's like somebody drawing on a chalk. Well, no, there's little or no excuse for not having an accurate scale model of the thing to show to the jury. Because let's remember that the prosecutor's job is to convict. And so if it's easier to skew a hallway and not show furniture so the place looks bigger, they're going to do it.
Mm-hmm. And another part that Pequalsa says is, like you guys were saying, I see no reason this model couldn't have been done in a week or two. And this is coming from someone who was doing it part-time for 4 years. So yeah. I thought that was a really interesting comment on their part.
It's ridiculous. Kaylee's chat. Way too many potential reasons they had to destroy the house and block the jury from getting to the truth. Bullet holes, blood everywhere, sound tests, showing roommates could hear a pin drop, drug, DNA fingerprints in the home, not BK's. The entire case reeks of corruption. The genius PhD student drives his own white car to a night crime and buys the weapon from his own IP router. The case is heading for dismissal, appeal, or mistrial. I wouldn't count on that, but too many. I agree that there are too many holes in the Santa fairy tale. That's just, I mean, in the end, I think under pressure, the defense did assent to destruction of the house. And I said it in that episode, so I'll say it again, and that is, if it's my client and you want to put him in front of a firing squad, and yes, you do, I don't care what you say, Attorney Thompson, you want to put him in front of a firing squad, I'm getting a bus and taking the jury up to 1122 King Road in Moscow. Now, that's not an option now. I know it's not an option now, but I think, if there is a conviction, I think that would be one of a number of things that could show the overall issues in this case. I really do.
All right, LC 285. Gee, what happened to the Faro Technologies 3D production the prosecution was touting to showcase? It was on Idaho local news as the greatest crime scene recreation tool using laser LiDAR technology. They had over 2.5 years to complete this activity. This case is an exhibit of how not to investigate a quadruple H in a small town, rural America research university town. This whole case has been a demonstrative mock-up, and like we always say, these are viewer comments, not ours. But I definitely am on board with, we have the technology. If showing the house was going to be this essential, there's more effective ways to do it that aren't even very costly.
And I remember all the ballyhooing about the Faro Technologies, and I can't remember which documentary it was, whether it was 2020 or one of the others was talking about, it almost sounded like a salesman. Oh, Faro Technologies can show you, step on down and there's more. It sounded like one of those things that really, 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 touted the advantages of that program. And it might be a great program. I don't know. That's not my area, but I don't know. It just it seems silly. Douglas Outlaw. Wait a second. Didn't the prosecution basically admit they lost the Faro scans in court yesterday, like they misplaced a sacred relic from a CSI museum? Then Ann Taylor rolls in talking about that Barbie Dreamhouse setup, arguing it needed to be built with precision, real tools, not duct tape and good intentions. Don't forget the Elmer's glue. But Bill Thompson waves it all off like, yeah, it's just for show. Scale doesn't matter. And Judge Hippler just shrugs off like, yeah, that'll do. That ain't lawyering. That's Home Depot justice. No, I can just see somebody in the back aisle of Home Depot or Lowe's, with a little this. Yeah, we need a little bit of, this, a little bit of that. We need the duct tape. We need some Elmer's glue. We need some drywall and a saw. Yeah, we'll just throw it together. Home Depot justice, no blueprint, no permit, just vibes and a gavel. So can't the defense still use their own Faro scans and the state can use their dollhouse? Well, since we've done that episode, now there's been a hearing on that issue. And the judge basically said, well, defense, you had the opportunity. You could have done your own. So the answer to your question is, yeah, they could use their own scans. They could use but just before the house was demolished, the defense was allowed to go in with their own scanning equipment. And the judge said, look, if you don't like the prosecution's model, you could have made your own. So, that seems a little, talk about confusing the jury. Come on.
Yeah, it also, from my interpretation of it, seems like the prosecution kind of sprang this on the defense last minute where they're like, hey, can you agree to this so that way we can have it like sorted? It's just like to say that they had the opportunity, like the defense had the opportunity to make that dollhouse. Why would they want that dollhouse? They're arguing against it right now, so clearly they weren't interested in it initially. Like, was it their responsibility from the beginning to think, okay, well, the prosecution's going to want to admit this thing that's not to scale, let's make one to scale so that way we can do that? And there's no even way of guaranteeing that had they made it in advance that this still wouldn't have been an issue. Maybe they made it in advance and maybe the prosecution still wouldn't have liked it. It's just silly.
And the other little factoid that if you were watching the hearing in court regarding the dollhouse, whatever you want to call it, and I got some grief for calling it a dollhouse, but guess what? Attorney Thompson, Judge Hippler, and Ann Taylor all called it a dollhouse. One of the little factoids I got out of that was Ann Taylor was trying, not Ann Taylor, but William Thompson, the prosecutor, was trying to say, well, we were working with it, or it was actually Ashley Jennings was saying, well, we were working with the FBI and we were trying to work with the FBI and, we were going back and forth and we were emailing back and forth with Ann Taylor, to see if we could get an agreement. And the FBI on their own started before we were able to get this court order. So, the corrupt FBI, which used Whitey Bulger as a horrible informant and which has been known as a corrupt agency, they don't care about the court. They don't care about whether the prosecution and defense were trying, at least in that chain of emails that we read in the episode that we're talking about, they were trying at least to arrive at some kind of agreement. They weren't there. They didn't have an agreement, but they were communicating. The FBI didn't wait for that or a court order. They're like, heck with y'all. We'll just start it ourselves. So that alone should have made the court raise its eyebrows. But in any event, I don't know.
Our last comment today from Get More Holidays, maybe. Well, their creativity and enthusiasm is A+. I loved this one. Takes me back to kindergarten when I was asked to paint Santa Claus, and when I was finished, it was a fish tank with 3 goldfish and a banana.
It's like, you go to parents' houses. If you have any friends who are parents of kids, their refrigerators are covered with pictures of, you got to look. Is that a tree or a mushroom? Is that a dollhouse or a doghouse?
Is that 3 feet or 6 feet?
Yeah, exactly. Did he have time to get from Dylan Mortenson's room to the back deck or not? I mean, and that's the serious issue that we've been making light of, and I'm sure we'll get nasty comments about that. But one last editorial comment, and that is that, we don't huckster. There are other attorneys on YouTube, very good attorneys, but they sell stuff. They're in the middle of explaining to you a case, and oh, by the way, how about buying this? Isn't this great? Isn't this great? We don't do that. We don't sell mugs. We don't sell T-shirts. We're not like, all we want is a subscription. We hit 15,000 this week and we're going for 100. So
we'll get there soon. But to help us get there sooner, be sure to comment socks down below, little sock emojis or whatever emoji you please today, honestly. But be sure to like this video and subscribe to our channel if you haven't already, to help us on our very long, I mean short, not long at all, very, very, very short journey to 100,000 from 15,000. But
well, we'll get there. And so please give us a subscribe, and thank you for being with us. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.